Ladies and gentlemen, I'm going to speak to you about the artificial intelligence which is creating havoc around the globe. How it happened in my case, I'm going to explain this in short. In the month of October 2017, the US Supreme Court granted me permission to file a writ of mandamus in case number In Re Talakotur, case number 16-9624. But what happened was the clerk of the court, a woman by the name Blalock, refused to read the Supreme Court's order in case number 16-9624. She thought it is a case which was dismissed by the court in case number 15-9100. She refused to take the money I sent and returned the brief back to me to India in 4 boxes. I tried to reach this woman on the phone. She won't answer, nor her supervisor, Jeffrey Atkins, who advised me to leave a message. And I left not one, several messages, but they won't return my call. Although I had at that time a toll-free number from the United States to India and back. To cut the long story short, this woman returned the papers. I sent a letter to Chief Justice John G. Roberts requesting him to accept the check. I sent it back to Chief Justice Roberts, who in turn forwarded it to one Jeffrey Atkins. Although Jeffrey Atkins corrected the error made by the first woman as case number 15-9100, he read the correct case number, which is 16-9624, but he refused to read the court's order in full, which on page 32 clearly stated the purpose. Ladies and gentlemen of the jury, you decide after sharing me the artificial intelligence, how it creates havoc around the globe. On October 2, 2017, the United States Supreme Court granted me permission to file a writ of mandamus in Re Talakotu, case number 16-9624. But when I paid the money to the clerk of the court, $300, with the 40 sets of brief, the first clerk, a woman by the name Melissa Blalock, returned the whole papers back to me, telling me the Supreme Court dismissed the case in case number 15-9100, which is not the case. The US Supreme Court granted me to file the papers and pay the fee pursuant to the rules of the Supreme Court. I promptly paid a bank draft made payable to the clerk of the court, but Blalock rejected and refused to accept and returned them back to me to India in 4 boxes due to her lack of knowledge or error in failing to read the Supreme Court's order. I sent the bank draft to Chief Justice Roberts, requesting him to direct to the clerk of the court to accept the fee and submit the papers. And Chief Justice Roberts forwarded the papers, the check, to the clerk, Jeffrey Atkins, to do the needful. Jeffrey Atkins, while correcting Blalock as the case 169624, refused to accept the fee under the pretext the Supreme Court denied the petition, which is not the case. The Supreme Court had mentioned clearly and unequivocally the order, which is shown in order number 52 USC, which showed at the relevant portion of the order, I believe page 32, the cases that were denied by the court and those not denied, as you can see, my name was missing, which means the Supreme Court clearly meant what it said. So both the clerks were wrong. Jeffrey Atkins, I wrote the letter Jeffrey Atkins later on sent a letter to me saying, raising, so to say, a constitutional question under Article 3 of the US Supreme Court. But when it was pointed out, Jeffrey Atkins refused to accept the fee. He raised a constitutional question, and I wrote him to say he is not the counsel for the defendant, but a clerk of the court, and his job was purely ministerial to carry out his functions as commanded by the Supreme Court in its order, Supra. That the battle between myself and Jeffrey Atkins went on. Jeffrey Atkins sent the bank draft back to me again with my brief. This game of sending it to the clerk of the court, their returning, went on as many as 7 different times. I moved to the Disciplinary Council, DC Columbia Circuit, to take action against Jeffrey Atkins, Scott Harris, and they refused, saying and justifying Scott Harris had performed his duties pursuant to the rules without submitting the same to Chief Prosecutor as required under the rules. This letter was returned by stop it. So the game of returning back and forth the papers between myself and various clerks continued for 5 more years with no relief whatsoever. Everyone questioning the Supreme Court's order, which is clear and unambiguous. The Columbia Circuit, to whom the case was referred, they refused to address the question. It went to, after 5 months waiting, to one Neil. What's his name? Full name?
Bikini.
Eh?
Bikini.
No, not Neil, the other guy. Went to the judge. Neil, stop it. So the papers went to Carl Nichols. Carl Nichols held that my 32-page complaint is too lengthy for him to read. He wants me to explain my 38 years litigation at that time. Is too much for him to read. He cited Federal Rules of Civil Procedure 8, 9 and 10 and local rule in support, which nowhere said the page limit. But Carl Nichols wanted me to reduce my size of my complaint to 15 pages, double-spaced. There is no rule in the Federal Rules of Civil Procedure 8, 9 and 10, the number of pages one's initial complaint should be. From there, it went to a 3-judge panel. The 3-judge panel at the Columbia ruled it has no jurisdiction. Then it went to the en banc court. The en banc court apparently denied that, including the justice was soon going to be appointed as one of the justices of the Supreme Court. The order was masked by a paper by the clerk of the court and submitted that letter to another judge, Chudkan. Chudkan wrote in her letter that I should comply with the rules as stated by the first judge, and she posted a letter which arrived a couple of days before the due date. And she issued an order dismissing the case. This game went on for 7 times with the various clerks. The question for consideration is whether any of the lawyers involved have played fraud. The fraud was committed by the first Florida lawyer by the name Peter Wolf Zimmerman, who stated in his false jurisdictional statement one word, extra word. The statement said the court dismissed the case and the clerk entered an order. That was not true. The court never addressed the question with regard to my Title VII and ADA claims. It only referred to the tenderback. Tenderback was not a legal issue. It was a proposed defense articulated by the defendant by planting a test case in Michigan, and after obtaining a per curiam unpublished order, moved the Tampa court to dismiss the case, which it did by issuing an order to dismiss the case without prejudice. The clerk of the court, instead of carrying out his duties, he changed the court's order as a dismissal on the merit. And I learned later on the clerk, Donald Brown, had done identical things in several other cases, and he was fired by the court, the Tampa court, by Justice, two judges, and he was fired. So the name of the game was using the clerk of the court to alter the court's order from a dismissal without prejudice on the merit, so that the appellate court can have jurisdiction. If he didn't alter the court's order, there was nothing to appeal, because interlocutory orders are not appealable pursuant to 1292 U.S.C. Okay. So the plan contrived by Peter Wolf Zinneber misfired. So what happened was, when this case was pending in the United States Court of Appeals for the 11th Circuit under FRAP 35, two judges, Judge Marcus and Jeffrey, Judge Marcus and Edmondson, they held, although they are retired judges, they have the authority to consider the motion, the FRAP 35 motion, while the 12 other Circuit Court of Appeals held that to consider FRAP 35 should be heard by a panel of 3 active judges. So there is a conflict between the 11th Circuit versus the 12 other Circuit Court of Appeals in the whole nation. So under Rule 10 of the Supreme Court rules, when there is a conflict, the Supreme Court has authority to intercede in the matter. Okay, that's one issue. Now, when I filed a claim in New York for getting my pension from my employer, AT&T in Michigan, well, they brought a Brian Wayne Tilker, who was hired by the chairman of the Democratic Party's Rules Committee, Ralph Curtis Dawson. Dawson advised Tilker to file a false affidavit, and Tilker submitted a false affidavit. You can see a copy of the affidavit filed by Tilker. In the affidavit, he stated, under penalties of perjury, he has personal knowledge of the facts stated herein. Based on Tilker's affidavit, the Seibert Court granted a summary judgment, although there is no provision in the rules to grant a summary judgment when there are triable issues of material facts exist in the case, as ruled by Judge Reed of Orlando in a pre-motion conference. There were 3 precedent-setting cases which was heard and decided together, one after the other, in 3 precedent-setting cases. So Judge Seibert was wrong in granting a summary judgment. When I did investigation, I learned Tilker was a child of 2 years old living in New York at that time. And there is no possibility for him to testify what happened in Michigan, where I was forced to sign a release under duress, coercion and through fraud. His testimony was false. When it was pointed out to Judge Seibert, she was wrong. He used the 2-year-old Tilker's affidavit 18 places in her impugned order. And Seibert refused to do so, saying in her 10-page order, amended or second order, that Tilker can do so while moving for summary judgment. She was writing an opinion on her own without regard to the rules framed by the United States Congress. So the name of the game here is to deprive me my right to liberty and property without the due process of the laws. During a pre-motion conference, which was held by Seibert and Dawson on the phone, she asked Dawson, "Do you want any discovery for Mr. David?" So Dawson said plainly, "No." You can see the colloquy between Dawson and Seibert and how she refused to grant me any discovery. That is part of the record. Now the problem here is Tilker, who filed the false affidavit, fled to the state of Hawaii, which is a safe haven for the Democrats, and went to work for a law firm, which I don't remember now, who alleged that Tilker is not licensed to practice. And they directed me to conduct the New York bar. The New York bar is now conducting an investigation, the role played by Ralph Curtis Dawson, which is exhibit, whatever the exhibit, again put it. Okay? So the issues here are simple. My right to liberty and property were taken away without the due process of the laws by the kangaroo courts, not the justices, the clerk. So the question that I wish to raise is what punishment you are going to match to these two clerks, especially Jeffrey Atkins. And I am sure the civilized world will understand what goes on, how the AI is aiding and abetting. Because I looked in the AI and I asked the question. So every time you ask the question, they say your case is dismissed. And I asked the AI, what happened to line 4, 5, and 6 of the court's order? Then they keep mum. The AI is set to protect employees. So I hope civilized world will understand. I will soon be filing my petition for a writ of certiorari We are working on it because there are too many issues. The Supreme Court has recently amended its rules. I was doing everything pursuant to the prior rule, but Supreme Court has lately amended the rules and we can't renumber all the appendixes. So I want the civilized world to understand. If any of you are a producer interested in this thriller movie, the type of corruption, you should contact me on my Indian phone, which is +919656058330, and my email address is trdavid2009@gmail.com, spelled T Tom R Robert David, DAVID 2009@gmail.com. Thank you, ladies and gentlemen. Bye-bye.